So, good evening, everybody, for this second 45 minutes focus on law and geopolitics. The second meetings will host Professor Paolo Passaglia, which is also the coordinator of the summer school, and Dr. Laura Ricci, which is postdoctoral research in criminal law at the University of Corsica. And today they will try to debate thoroughly and insightfully a topic which can seem just a little bit at odds one each other, but it's interplayed and has a lot of embedded issues at stake, which is death penalties and geopolitics. So I leave the floor to Professor Passaglia, the coordinator, and then to Laura Ricci and her insightful, challenging topics.
Thank you very much, Giovanna. Today we're going to talk about geopolitics and death penalty. Death penalty and its abolition have been for a long time purely ethical and religious issues. During the Enlightenment, we can think about Beccaria, both issues have become also philosophical and sociological issues. Um, in the middle of the 19th century, with some anticipations in Tuscany, namely, and some extent in France, these issues have become also political issues. And quite recently, let's say during the second part of the 20th century, death penalty and its abolition acquired a new dimension so that they can be considered present also not insignificant geopolitical issues. The geopolitical impact of these issues can be observed from several points of view. So in my presentation, I would focus on, let's say, 7 points of view that, in my opinion, can link this issue, this legal, philosophical, sociological issue with geopolitics. The first, the first issue, the first point to think about is that the number of abolitions is so high that in some regions of the world, there is a concrete goal to eradicate death penalty from a whole continent. We can just have a look um, to the to this map, and this map shows that Europe, apart from Russia and Belarus, is a completely death penalty free continent, as well as Oceania is roughly free of death penalty. But also, to some extent, the South America is a continent in which the death penalty is almost eradicated. The abolition of death penalty, let's say in the second point that we could think about, can be the expression of a new beginning for the national legal system. In this regard, the abolition can be a sign that a country shows of the will to join a certain tradition, a certain new tradition, to join a certain group of states. In this regard, I think that notable examples can be those of Italy or Germany or Spain. In Italy, after the fascist regime and the Second World War, the same happened with Germany, the West Germany, of course, with the Nazi regime, but later in Spain with the end of the Franco dictatorship. We can also add the case of France, in which there was no regime to eliminate, but it was a turning point, that of 1981, a political turning point with the left that came to government after more than 20 years. And one of the grounds for abolition was that all France's neighbors ended up with abolishing death penalty. So even France had to abolish it in order to be part of a common core, let's say. The third point is, I think, uh, much more geopolitical, and it deals with what happened in the 80s. In particular, in the 80s, there was a new approach to death penalty because the death penalty became part of a sort of international law, and in particular, the human rights international law with several different instruments and protocols to European and international conventions. We could also look at this. Sorry, I cannot find. Yeah. Okay. We can look at this list. This list, you see several protocols from the sixth protocol to the European Convention on Human Rights, 1983, to the second optional protocol of the International Covenant on Civil and Political Rights, adopted by the General Assembly of the United Nations in 1989, then the protocol to the American Convention in 1990. All these protocols created a sort of international law concerning the abolition of death penalty. That created a situation in which several countries abolished death penalty in order to comply with their international obligation. There were different paths, but the idea was to comply with international obligations, abolishing death penalty. In some cases, the abolition at the national level was a simple consequence of the ratification of the international or the supranational law instrument. For instance, in Europe, in Estonia in 1998, or Albania in 2007 for the full abolition, Latvia in 1999 for partial abolition, and in 2012 for the full abolition, Mongolia, Benin, with the ratification of the second protocol, are all cases in which the abolition at the national level was the result of the ratification of the international law instrument. In some other cases, national abolition was adopted just before the country ratified the international instrument concerning abolition. For instance, in Turkmenistan, there was a law abolishing death penalty in 1999, and then the ratification of the international instrument the year later. The same happened in Rwanda in 2007, Uzbekistan 2008, Argentina 2008, and more recently in Zambia 2023. And the ratification of the international instrument was in 2024. Again, the national abolition of death penalty can also be required by the international obligations of the countries, and that happened in particular with several cases of judicial abolitions. Let's say courts, or constitutional courts, or supreme courts, declare unconstitutional the death penalty precisely because death penalty is inconsistent with the obligation deriving from international law. Some examples can be those of the Constitutional Courts of Hungary, 1990, Lithuania, 1998, Albania or Ukraine, 1999. More recently, Guatemala, 2016. But the influence, not the obligation, but the influence of international law, as well as comparative law, was quite strong with the Declaration of Unconstitutionality delivered by the Constitutional Court of South Africa in 1995. We could also add the Human Rights Chamber for Bosnia and Herzegovina in 1997. And there is a quite interesting and quite peculiar case with the Constitutional Court of Russia in 2009. In Russia in 2009, the death penalty was suspended because the regulation of the jury trial was found unconstitutional. And since in order to sentence to death, a jury was required, no death penalty could be sentenced because could be provided because there was no jury. But the Constitutional Court, while deciding on the reintroduction of that, of jury by trial, declared that this reintroduction was inconsistent with Protocol number 6 of the European Convention of Human Rights. And Russia did not ratified the protocol, but did not implement it. But the simple fact of having ratified this protocol prevented Russia from taking step back. So in 2009, there was a moratorium because of the jury trial found unconstitutional. And so the Russia, after this moratorium, could at least remain a de facto abolitionist country and not going back to the execution of death penalties. Of course, after 2022, the situation has changed, but so far no execution were carried out in Russia. The fourth point that I would like to discuss is that abolition can be part of a global strategy of a country. For instance, and in particular, a country that aims to become part of a supranational organization can have a particular policy on death penalty. The most notable case in this regard is Turkey. In Turkey, the death penalty was partially abolished in 2002 and fully abolished in 2004. And both decisions were among the requirements to be part of the European Union. At that time, Turkey was a candidate for membership. So if Turkey wanted to become part of the European Union or try to, had to first abolish death penalty. The fifth point is that a less significant maybe expression of the global strategy, but still an interesting strategy of the country is represented by the abolition that is decided or at least prepared in order to become part of the, let's say, the majority club of the abolitionist states in the United Nations. A club that increases the number of membership over the resolution. You know that since 2007, several resolutions were adopted by the General Assembly of the United Nations. And sorry for that. Sorry, I'm trying to find the good thing, the good point. Yeah, these resolutions. The first resolution was adopted in 2007 with 404 votes in favor and 54 against. And the last resolution so far was adopted in December 2024 and with 130 votes in favor and only 32 against. That means that there is a sort of increasing consensus toward the abolition of death penalty. And to some extent, we can say that it is not only a simple matter of numbers, It is rather a matter of reputation in terms of values or maybe in terms of modernity, I don't know. Indeed, with notable exceptions, the abolition of death penalty is associated with the idea of implementation of liberal democracy, namely the transition to liberal democracy or its consolidation and the strengthening of the protection of human rights. Here comes the sixth point. Uh, and my sixth point deals with another pivotal issue, namely the American exceptionalism. The American exception, I'm talking about, of course, the US. Uh, the US exceptionalism uh, emerged only during the 70s because before July 1976, there was no exceptionalism since the US were approximately at the same level of most of the major countries in the Western tradition of the Western tradition. In 2072, with the Furman v. Georgia case, the United States Supreme Court declared unconstitutional the regulation of death penalty, and this unconstitutionality led to a sort of moratorium of the death penalty until 1976, with five judgments on July the 2nd, 1976. The United States Supreme Court declared the death penalty as such not inconsistent with the Constitution. That led to a clear cut between the two shores of the Northern Atlantic Ocean. And the major difference between Europe and the US allowed Europe to be at the forefront of the abolitionist movement. And with reference to death penalty in particular, Europe plays a key role as a human rights-oriented global geopolitical actor, at least since the end of the 70s. And it is quite interesting to think about that because we can consider that this role concerning death penalty can be a sort of anticipation of a more general geopolitical scenario. The geopolitical scenarios that appears nowadays when Europe is trying to maintain, at least as much as it can, a human rights centered approach to the international relations. And this human centered approach is particularly important if compared with the considerable change in this regard that was adopted by the Trump administration. So I come to Trump and Trump's policy concerning death penalty. That is the seventh and final point that I would like to discuss with you. The reference to the US introduces some considerations that can start from analyzing an interesting an interesting trend. These are the number of executions after 1976, of course, when the US Supreme Court allowed again to execute death penalty. And you can see that there is a trend, a clear trend of increasing number of death penalty of executions, sorry, up to the end of the 20th century. But then there is a sort of the opposite trend at the beginning of this century, going to 2020, when the number of executions was very, very low if compared with with the previous years. It is interesting to highlight the fact that 2020 is a pivotal year because in 2020, President Trump reinstated executions in the federal jurisdiction, but at the same time, President-elected Biden announced measures against death penalty. That led to consider, even if not possible, but not impossible, let's say, an abolition of death penalty in the US. Uh, the problem is that these measures were not adopted. And at the end of the day, the number of executions increased over the years after 2020 and increased considerably so that you can see that in 2021 the number was only 11, then 18 in 2022, 24, 25 2024, 47 in 2025. The first year of the second President Trump's term was a year in which the executions nearly doubled if compared with the previous years. And this is linked quite likely to the fact that President Trump wanted or declared that he wants to allow again federal jurisdiction to execute prisoners. Sorry, the inmates. This data could suggest that death penalty is well rooted in the US. We can say that it is true, but nevertheless, a geopolitical approach to this issue can help understand that death penalty is actually far from being a nationwide phenomenon. The reason is that if we look at it, if we consider, we can see that almost half of the states are abolitionists. 23 states repealed death penalty. 23 states, 4 territories, and 1 district. Then there are 6 other the green states. The blue states are the states in which executions were formally suspended, and the yellow states are those that in which there was no execution in the last 10 years, so they can be considered de facto abolitionists. And in violet, there is the state in which executions are informally suspended. As a result, only in 16 out of 50 states, there was at least 1 execution in the last 10 years. And if you look at the map, you see that the places in which execution took place are considerably concentrated in the south and in the, let's say, in the south east. This is particularly true if we also consider that from a geographical point of view, the phenomenon of execution is particularly concentrated not only with reference to states, but also with reference to counties. Sorry. This map shows the executions since 1976, and you see that the executions are quite concentrated in rather a rather limited number of counties. So, taking into account this map, we can question whether the death penalty in the US is really a nationwide phenomenon. If we consider this map, we can be a little worried about the most recent trend. If we compare the executions in 2020 and in 2025, we can see that in 2020 there were federal executions, but then apart from these federal executions that were carried out at the very end of the Trump first term, there were only 5 states in which execution took place, and they were very concentrated. If you compare this map with that one, you can see that executions gain momentum. It is not only a problem of number. Of course, it's a problem of number. If you look at 19 executions in Florida against 0 execution in 2020, you can consider that there is a problem with executions in Florida. But you see that we have problems in Florida, but also in several other states. 11 states carried out execution in the US last year. That is to say that the geopolitical approach can help us in understand how the death penalty can be considered in which to which extent and in which way we can understand death penalty as a global phenomenon. The abolition can be considered a global phenomenon, but also with reference to retentionist countries, we can consider that this policy is very often quite concentrated policy. Well, I stop here. I talked even too much, so I thank you for your attention and sorry for being a little long.
So please, Dr. Laura Ricci, the floor is yours.
Thank you. I hope you can hear me. Okay, perfect. Thank you for this invitation. I will try to be very brief and just pose a few questions from the perspective of a penal lawyer, which is quite different from the geopolitical one, of course. So excuse me in advance if something would not fit the purpose of this webinar. But anyway, as a European criminal lawyer, we often take for granted that capital punishment is an obsolete remnant of a past, of a pre-modern conception of punishment, a past which is far from remote, in fact. But let us say that it's a commonplace to portray death penalty as a relic of a pre-modern conception. It is also a quite recurrent trend to address death penalty in this way, also in the American scholarship. For example, Mary Atwell observes that the United States stands alone among developed democratic countries in continuing to permit the use of this punishment. And but it is precisely the American example that calls into question this assumption that the death penalty is necessarily a feature of undemocratic systems deficient in their protection of human rights. Because there is a correlation, of course, but it is not exclusive. And this raises some questions. So my first question is this one. Is it still possible to argue that the acceptance of this form of punishment can be attributed to specific, still to be attributed to specific legal tradition that cannot simply be dismissed as backward or pre-modern. I realize that this question quite sound uncomfortable, maybe provocative. Nevertheless, we cannot overlook the fact that the strong personalism which pervades the constitutions of the, for example, European countries, this attitude imposes a radical rejection of the penalty. But other constitutional frameworks might, for cultural, religious, or traditional reasons, not impose this strong rejection, retaining, for instance, that sometimes the individual could be subordinated to the interests of the community. One example could be the one of South Korea, which is a de facto abolitionist, since, if I'm not mistaken, there is no execution after 1997, but that anyway retains that, in principle, death punishment could be still considered constitutionally compatible, since in some cases life could be deprived if there is a justification such as national security, public order, or general welfare. So this kind of approach is quite far and unacceptable for our tradition. If I think of Italy, for example, we are still debating if some kinds of incapacitating measures, for example, the security measures for responsible offenders, or the case of the life imprisonment, the ergastolo stativo, still raises some concern, because we know that it is immanent to our system that we cannot use the person as a mean to an end. To quote Bettiol, individuals cannot be sacrificed in the name of a non-value, namely the state, which has the sole aim of realizing the necessary conditions to guarantee the full development of the human person. This is a reflection of 1962, and the memories of the fascist regime is quite vivid, I would say, because in that case, these terms were exactly opposite: before the state and after the individual. But after the Constitution of 1938, it is clear that there is no possible room for this kind of this state of things. So before is the person, and then the state. And secondly, we cannot accept a retributivist approach, which is still, I think, quite used, for example, in the US. So we cannot accept, because it is a system of a positive law, and we cannot accept, or we are not entitled to impose a universalistic moral scale of values. And this implicates that we cannot see proportionality between effect and the death penalty. It is impossible to recognize a proportionality. It is in some ways what Camus says when, to quote Camus, beheading is not simply death. It is just as different in essence from the privation of life as a concentration camp is from prison. It is a murder, to be sure, and one that arithmetically pays for the murder committed. But it adds to death a rule, a public premeditation known to the future victim, an organization, which is in itself a source of moral sufferings more terrible than death. So it is impossible to establish a proportionality between the committed fact and capital punishment. For these reasons, in our tradition, it's not acceptable nowadays to have capital punishment. But we do know that this is a result of historical developments, quite recent also. And if we look at things from this perspective, how could we deal with other approaches who retain, for example, that consider death penalty more, let me say, acceptable than life imprisonment, which is, for example, the case to some countries in the East. So how could be, which could be a winning strategy for the abolitionist cause facing these objections? First, second question. And in addition, to conclude, I would like to ask you if you think that the gradual convergence of values, driven, for example, by the movement of people, the globalization of the law, the cross-fertilization between systems, might sooner or later benefit the abolitionist cause. Also consider the rise in so-called cross-jurisdictional cases, which, for example, have been considered in the case of the US as quite complicated cases because in the past years, some executions were addressed to non-citizens, and these were clearly cases in which there was a potential conflict of jurisdictions. So thank you. I hope that my questions are clear.
Thank you, Laura. So, Paolo, if you want to reply, and we have 5 minutes left.
Well, thank you, Laura, for this very tricky question, I would say. I will try to answer. Well, I don't have actually real answers. I can try to make some comments on your intervention. I think that, of course, if you one of the main issues is to consider the purpose of punishment, because if you consider punishment as its goal as socialization of the inmate, of course, death penalty is not acceptable. On the other side, if you consider the main goal as retribution, well, you can find, for instance, even in Christian tradition, several important confirmation in the Old Testament that allow capital punishment. So it is. I wouldn't say that it is the Western tradition against the others tradition. There can be different approaches to this issue that can have a relationship with religion, for instance. But I wouldn't say that Christians are against death penalty. Depends. It depends on what you're focusing on. With reference to the US, I think that one thing that we should consider is that death penalty is politically very sensitive. Because of course, if you ask people, are you in favor of death penalty? And in particular, if you ask victims or collateral victims if they are in favor, and you let them speak at the TV, of course you hear a clear statement in favor of death penalty. That is to say that it is never easy for politics to create the conditions to abolish death penalty. The French case is one of the few exceptions, in my view, with the UK and Canada, in which, for instance, in particular, in which politics decided to abolish death penalty. Generally, death penalty is abolished when there is some, I wouldn't say revolution, but there is a cut in the history of the legal system, and in this cut, you find the way to abolish death penalty. The US are very interested in this from this point of view, because the Supreme Court, when declared unconstitutional the regulation, not death penalty, but the regulation as it was in 2072, actually de facto abolished a capital punishment that in the last 5 years had only one case of execution. So probably the US Supreme Court thought that there was time to abolish that penalty. Then politics used this declaration by the US Supreme Court to talk to people and to find demagogic, of course, consensus. And then after that states reinstated the death penalty, US Supreme Court found that had no possibilities, no legitimacy to go against politics and political legislators. As a result, the Supreme Court, since 2076, accepts the principle of death penalty. And what the Supreme Court says, its case law is basically limiting what is the most unacceptable of death penalty. For instance, minor or mentally ill people, or death penalty for people who did not commit homicide, etc. So they try to limit the sharpness of the death penalty, but cannot look at the principle. So probably this is one of the issues that we could consider. Politics itself is not able to go against this death penalty as such, because it is too easy to protect death penalty from a political point of view. It needs something else that can be revolution, can be some uprising, etc., or international law. And in this regard, what we can find is that international law in the last decades played a major role in developing abolitionist movement. But now, what we could ask is whether international law is still standing to do this, considering how it's treated during the last year, and how it was treated, and how probably it will be treated in the next future. So I would stop there, because I see that we are almost at 45, and I want to respect the time limit. Thank you.
Thank you, everybody. Laura, do you have a little small time for a reply? 1 minute, or if you're okay, we say...
Okay, thank you. So I won't. Thank you for your answer, Professor.
So thank you, everybody, for attending also the second meeting, and we'll see you next Monday with the third and last seminar, Focus.